In the realm of international travel and immigration, Canada stands as a beacon of opportunity and a welcoming destination for individuals from all walks of life. Known for its diverse culture, stunning landscapes, and high quality of life, Canada attracts millions of visitors and immigrants each year. People come to Canada for various reasons, including tourism, education, employment, and to reunite with family members. The country's reputation as a land of opportunity is well-deserved, with its strong economy, excellent healthcare system, and commitment to human rights and social justice. However, the privilege of entering and residing within its borders comes with certain conditions and legal parameters. The Canadian government has established a comprehensive set of rules and regulations to manage the flow of people into the country. These rules are designed to ensure that those who enter Canada do so legally, and that they do not pose a threat to the safety and security of Canadian society. The immigration process involves various checks and balances, including background checks, medical examinations, and the assessment of an individual's criminal history. One such crucial aspect is the concept of criminal inadmissibility. This term refers to the legal provisions that prevent individuals with certain types of criminal records from entering or remaining in Canada. Criminal inadmissibility is a key component of Canada's immigration policy, reflecting the country's commitment to maintaining a safe and secure environment for its citizens and residents. The laws governing criminal inadmissibility are detailed and specific, outlining the types of offenses that can render a person inadmissible and the circumstances under which exceptions may be made. Canada, like many other sovereign nations, maintains a robust immigration system designed to safeguard its citizens, residents, and national interests. This system is built on a foundation of laws and regulations that govern who can enter the country and under what conditions. The goal is to strike a balance between welcoming newcomers and protecting the public from potential risks. Immigration officers play a crucial role in this process, carefully reviewing applications and conducting thorough background checks to ensure that individuals seeking to enter Canada meet the necessary criteria. A cornerstone of this system is the principle that individuals with criminal pasts may pose a risk to Canadian society and, therefore, may be deemed inadmissible. This principle is based on the idea that past behavior can be an indicator of future actions. By preventing individuals with certain types of criminal records from entering the country, Canada aims to reduce the likelihood of criminal activity and protect the well-being of its citizens. The laws regarding criminal inadmissibility are designed to be fair and just, taking into account the nature and severity of the offense, as well as the time that has passed since the crime was committed. Criminal inadmissibility essentially means that a person is barred from entering or remaining in Canada due to prior involvement in criminal activities. This can include a wide range of offenses, from minor infractions to serious crimes. The specific criteria for criminal inadmissibility are outlined in the Immigration and Refugee Protection Act, RPA, which is the primary legislation governing immigration in Canada. Under the IRPA, individuals may be deemed inadmissible for reasons such as having been convicted of a crime, having committed an act outside of Canada that would be considered a crime if it were committed in Canada, or being involved in organized crime. This policy reflects Canada's commitment to upholding law and order, protecting public safety, and ensuring the integrity of its immigration system. By enforcing strict rules regarding criminal inadmissibility, Canada sends a clear message that it takes the safety and security of its citizens seriously. The policy also serves as a deterrent to those who might consider engaging in criminal activities, knowing that such actions could have serious consequences for their ability to enter or remain in Canada. The enforcement of these rules is carried out by various government agencies, including the Canada Border Services Agency, CBSA, and Immigration, Refugees and Citizenship Canada, IRCC. The implications of criminal inadmissibility can be far-reaching, potentially affecting individuals seeking to visit family and friends, pursue employment opportunities, or establish permanent residency in Canada. For many people, the prospect of being deemed inadmissible can be a source of significant stress and anxiety. It can impact their personal and professional lives, as well as their future plans. Understanding the rules and regulations regarding criminal inadmissibility is essential for anyone with a criminal record who wishes to come to Canada. There are various resources available to help individuals navigate this complex area of immigration law, including legal professionals who specialize in immigration cases. Understanding the intricacies of this legal framework is paramount for anyone with a criminal record who aspires to step foot on Canadian soil. It is important to be aware of the specific offenses that can lead to inadmissibility, as well as the potential avenues for overcoming this barrier. In some cases, individuals may be eligible for a temporary resident permit, TRP, or criminal rehabilitation, which can allow them to enter Canada despite their criminal record. These options require careful consideration and often involve a detailed application process, including the submission of various documents and evidence to support the individual's case. Seeking legal advice from an experienced immigration lawyer can be invaluable for individuals facing criminal inadmissibility. A lawyer can provide guidance on the best course of action, help prepare the necessary documentation, and represent the individual in dealings with immigration authorities. Legal professionals can also assist in understanding the nuances of Canadian immigration law and the specific requirements for overcoming criminal inadmissibility. This support can make a significant difference in the outcome of an individual's application and their ability to enter or remain in Canada. Canada's approach to criminal inadmissibility is part of a broader commitment to maintaining a safe and inclusive society. The country prides itself on being a place where people from diverse backgrounds can live and thrive together. By enforcing rules that prevent individuals with certain criminal histories from entering the country, Canada aims to protect this inclusive environment and ensure that all residents can enjoy a high quality of life. At the same time, the country recognizes the importance of fairness and due process, providing mechanisms for individuals to address their inadmissibility and seek entry under certain conditions. Education and awareness are key components in addressing criminal inadmissibility. Many organizations and community groups offer seminars, workshops, and resources to help individuals understand the implications of their criminal records and the steps they can take to overcome inadmissibility. These educational efforts are crucial in helping people make informed decisions and navigate the complexities of the immigration process. By staying informed and seeking the right support, individuals with criminal records can increase their chances of successfully entering or remaining in Canada. The Canadian government also provides a wealth of information on its official immigration website. This site includes detailed guidelines on criminal inadmissibility, the application process for temporary resident permits and criminal rehabilitation, and other relevant topics. It is a valuable resource for anyone seeking to understand their options and the requirements for entering Canada. The website is regularly updated to reflect changes in immigration law and policy, ensuring that individuals have access to the most current information. For many individuals, the ability to enter Canada is not just a matter of personal or professional interest, but also a deeply emotional one. Reuniting with family members, pursuing new opportunities, and starting a new chapter in life are all powerful motivations for overcoming criminal inadmissibility. The journey may be challenging, but with the right information, support, and determination, it is possible to navigate the legal hurdles and achieve the goal of entering or remaining in Canada. In conclusion, criminal inadmissibility is a significant aspect of Canada's immigration system, reflecting the country's commitment to safety, security, and the rule of law. While the rules can be stringent, they are designed to protect the well-being of Canadian society and ensure that those who enter the country do so with respect for its laws and values. For individuals with criminal records, understanding these rules and seeking the appropriate support can make a crucial difference in their ability to enter or remain in Canada. By staying informed and proactive, they can work towards overcoming the barriers of criminal inadmissibility and achieving their goals in Canada. The complexities of criminal inadmissibility in Canada have been thrust into the global spotlight with the case of former U.S. President Donald Trump. This case has not only captured the attention of legal experts and immigration officials, but has also become a topic of discussion among the general public. The intersection of high-profile political figures and immigration law is rarely straightforward, and Trump's situation exemplifies the intricate web of legal, political, and social factors that come into play. Following his conviction on 34 felony charges related to a hush money scheme, questions have swirled regarding his eligibility to enter Canada. These charges, which stem from allegations of financial misconduct and attempts to influence the outcome of an election, have raised significant concerns about the application of Canadian immigration law. The legal ramifications of such charges are profound, and they bring to light the stringent measures Canada employs to maintain the integrity of its borders. Trump's legal troubles have sparked widespread debate and analysis concerning the application of Canadian immigration law to high-profile individuals with criminal histories. Legal scholars, immigration lawyers, and policymakers have all weighed in on the matter, offering diverse perspectives on how Canada's laws should be interpreted and enforced in such cases. The debate extends beyond the legal community, touching on broader issues of justice, fairness, and the rule of law. His case serves as a compelling illustration of how criminal inadmissibility can have significant implications, even for those accustomed to international travel and influence. For someone like Trump, who has spent decades in the public eye and has wielded considerable power on the global stage, the prospect of being barred from entering a country due to criminal charges is both unprecedented and highly consequential. It underscores the far-reaching impact of criminal inadmissibility, which can affect anyone regardless of their status or influence. While Trump's situation is unique in its political context and global notoriety, it underscores the universal nature of Canada's immigration regulations. These regulations are designed to protect the safety and security of Canadian society, and they apply equally to all individuals, regardless of their background or notoriety. The principles of fairness and equality are central to Canada's immigration system, and they ensure that everyone is subject to the same standards and scrutiny. Whether one is a former head of state or an ordinary citizen, the same legal principles and criteria apply when assessing criminal inadmissibility. This includes a thorough examination of the individual's criminal record, the nature and severity of the offenses, and the potential risk they pose to Canadian society. The process is rigorous and comprehensive, reflecting Canada's commitment to upholding the rule of law and ensuring the safety of its citizens. Trump's case provides a valuable opportunity to delve into the nuances of Canadian immigration law and explore the potential challenges and avenues for overcoming criminal inadmissibility. The legal landscape is complex, with numerous factors to consider, including the possibility of rehabilitation, the passage of time since the offenses were committed, and the individual's behavior and conduct since then. Each case is unique, and the outcomes can vary widely depending on the specific circumstances and the evidence presented. By examining the specifics of his situation, we can gain a deeper understanding of the factors considered, the legal remedies available, and the potential outcomes for individuals seeking entry into Canada. This includes exploring the various legal pathways that may be available, such as applying for a temporary resident permit or seeking a criminal rehabilitation. These options provide a framework for individuals to address their inadmissibility and potentially gain entry into Canada, subject to the discretion of immigration officials and the fulfillment of certain conditions. To fully appreciate the implications of Trump's case, it is helpful to look at historical cases of criminal inadmissibility and conduct a comparative analysis. Over the years, Canada has dealt with numerous high-profile cases involving individuals with criminal records, each presenting its own set of challenges and legal questions. By comparing these cases with Trump's situation, we can identify patterns and draw insights into how Canadian immigration law has been applied in different contexts. For instance, there have been cases involving celebrities, business leaders, and political figures who have faced criminal charges and sought entry into Canada. These case studies provide valuable lessons and legal precedents that can inform our understanding of Trump's case. They highlight the importance of factors such as the nature of the offenses, the individual's conduct since the offenses, and the potential impact on Canadian society. Public opinion also plays a significant role in shaping the discourse around criminal inadmissibility. Media coverage of high-profile cases can influence public perceptions and, in some cases, even impact the decisions made by immigration officials. The intense media scrutiny surrounding Trump's case has brought the issue of criminal inadmissibility to the forefront of public consciousness, prompting discussions about the balance between security and fairness in immigration policy. Legal experts and policymakers continue to debate the best approaches to handling cases of criminal inadmissibility. Some argue for stricter enforcement of immigration laws to protect national security, while others advocate for more lenient policies that consider the potential for rehabilitation and the individual's contributions to society. These debates are crucial in shaping the future of Canadian immigration law and ensuring that it remains fair, just, and effective. The role of Canadian immigration officials is central to the process of determining criminal inadmissibility. These officials are tasked with the responsibility of reviewing applications, assessing the evidence, and making decisions based on the legal criteria and guidelines established by Canadian law. Their work is meticulous and requires a deep understanding of the legal framework, as well as the ability to weigh the various factors involved in each case. The immigration process involves several steps, starting with the submission of an application and supporting documentation. Applicants must provide detailed information about their criminal history, including any charges, convictions, and sentences. This information is carefully reviewed by immigration officials who assess the severity of the offenses and the potential risk to Canadian society. The process also includes opportunities for applicants to provide additional evidence and make their case for admissibility. Immigration lawyers play a crucial role in assisting individuals with criminal records navigate the complex legal landscape. They provide legal advice, help prepare applications, and represent clients in hearings and appeals. Their expertise is invaluable in ensuring that applicants understand their rights and options, and in presenting the strongest possible case for admissibility. Rehabilitation programs and initiatives are also an important aspect of addressing criminal inadmissibility. These programs aim to help individuals demonstrate that they have reformed and are no longer a threat to society. Success stories of individuals who have overcome criminal inadmissibility and gained entry into Canada serve as powerful examples of the potential for redemption and the positive impact of rehabilitation efforts. Looking ahead, there are several policy recommendations that could help address the challenges of criminal inadmissibility. These include measures to streamline the application process, provide clearer guidelines for assessing criminal records, and enhance support for rehabilitation programs. By implementing these recommendations, Canada can continue to uphold its commitment to security while also promoting fairness and justice in its immigration system. In conclusion, the case of former U.S. President Donald Trump highlights the complexities and challenges of criminal inadmissibility in Canada. It serves as a reminder of the importance of a fair and rigorous immigration system that balances security with the potential for rehabilitation and redemption. As we continue to navigate these issues, it is essential to remain committed to the principles of justice, fairness, and equality that underpin Canadian immigration law. The broader implications of this case extend beyond the individual circumstances of any one person. They touch on fundamental questions about the nature of justice, the role of immigration policy, and the values that define Canadian society. By reflecting on these issues, we can gain a deeper understanding of the challenges and opportunities that lie ahead in the realm of immigration law and policy. The consequences of criminal inadmissibility can be profound, disrupting travel plans, severing family ties, and hindering personal and professional aspirations. When someone is deemed inadmissible to Canada due to a criminal record, the ramifications extend far beyond the immediate inability to enter the country. It can create a ripple effect that touches nearly every aspect of their life. Severing family ties is one of the most heart-wrenching consequences. Imagine a scenario where a parent is unable to visit their child who is studying or working in Canada. The emotional toll of such separation can be immense, leading to feelings of isolation and helplessness. Family gatherings, holidays, and significant life events are missed, creating a void that is hard to fill. For individuals found inadmissible to Canada, the doors to this vibrant and welcoming nation may seem firmly shut. The sense of rejection can be overwhelming, especially when one has dreams and aspirations tied to the opportunities that Canada offers. The country's rich cultural diversity, economic opportunities, and high quality of life make it a desirable destination for many. The inability to enter Canada can have a cascading effect on various aspects of a person's life. It can disrupt career plans, especially for those in professions that require international travel or relocation. For instance, a business professional who needs to attend conferences or meetings in Canada may find their career progression stalled. Similarly, students who have secured admission to Canadian universities may have to forego their educational dreams. It can prevent individuals from reuniting with loved ones residing in Canada. The emotional strain of being separated from family members can lead to stress, anxiety, and depression. The inability to participate in family milestones such as weddings, births, and funerals can create a sense of loss and disconnection. Pursuing educational or employment opportunities becomes a distant dream. Canada is home to some of the world's top universities and offers a plethora of job opportunities across various sectors. Being inadmissible means missing out on these prospects, which can have long-term implications on one's career and personal growth, or simply experiencing the beauty and culture of the country. Canada is renowned for its stunning landscapes, vibrant cities, and rich cultural heritage. For travel enthusiasts, being unable to explore the Canadian Rockies, visit Niagara Falls, or experience the multicultural festivals in cities like Toronto and Vancouver can be a significant disappointment. Furthermore, criminal inadmissibility can carry a social stigma. The label of being inadmissible can lead to social ostracism, where individuals are judged and avoided by others. This can affect personal relationships, leading to feelings of loneliness and alienation. The stigma can also extend to professional settings, where colleagues and employers may view the individual with suspicion, potentially impacting an individual's reputation and future prospects. A tarnished reputation can be challenging to rebuild, especially in today's interconnected world where information spreads rapidly. Employers may be hesitant to hire someone with a criminal record, even if the offense was minor or occurred many years ago. This can limit career opportunities and hinder professional growth. The label of being inadmissible can be difficult to shake off and may cast a long shadow over one's personal and professional endeavors. The psychological impact of carrying such a label can be profound, leading to a diminished sense of self-worth and confidence. It can create a barrier to forming new relationships and pursuing new opportunities. Therefore, it is essential for anyone facing criminal inadmissibility to understand the gravity of the situation and explore all available legal avenues to address their status and seek potential solutions. Consulting with an experienced immigration lawyer can provide valuable insights and guidance on the best course of action. Legal professionals can help navigate the complex immigration laws and identify possible remedies, such as applying for a temporary resident permit or criminal rehabilitation. The path to overcoming inadmissibility may be challenging, but it is not insurmountable with the right legal guidance and strategic approach. Persistence and determination are key. By taking proactive steps and seeking professional assistance, individuals can work towards clearing their inadmissibility status and opening the doors to new opportunities in Canada. The journey may be arduous, but the rewards of being able to reunite with family, pursue educational and career goals, and experience the beauty of Canada make it worthwhile. Overcoming inadmissibility can lead to a brighter future. Reuniting with family members, achieving academic success, and advancing in one's career are just a few of the positive outcomes that can result from addressing inadmissibility. The sense of accomplishment and fulfillment that comes from overcoming such a significant hurdle can be life-changing. Experiencing the beauty and culture of Canada firsthand can be a transformative experience. From the majestic Rocky Mountains to the vibrant cultural festivals, Canada offers a wealth of experiences that can enrich one's life. Being able to travel freely and immerse oneself in the diverse and welcoming Canadian society is a privilege that should not be taken for granted. Reflecting on the journey to overcome inadmissibility can provide a sense of pride and accomplishment. It is a testament to one's resilience and determination. The challenges faced and the obstacles overcome serve as a reminder of the strength and perseverance required to achieve one's goals. The experience can also inspire others who may be facing similar challenges, showing them that it is possible to overcome adversity and achieve their dreams. Sharing one's story and offering support to others can create a sense of community and solidarity. By connecting with others who have faced similar challenges, individuals can find comfort and encouragement. Building a network of support can provide valuable resources and insights, making the journey to overcome inadmissibility a shared and collective effort. Celebrating success and embracing the opportunities that come with overcoming inadmissibility is a momentous occasion. It marks the beginning of a new chapter filled with possibilities and hope. The joy of being able to reunite with loved ones, pursue dreams, and experience the beauty of Canada is a reward that makes the journey worthwhile. Looking forward with optimism and planning for the future is the next step. With the burden of inadmissibility lifted, individuals can focus on building a brighter future. Engaging in new opportunities, setting new goals, and embracing the possibilities that lie ahead can lead to a fulfilling and prosperous life. Standing at the edge of a new beginning, looking out at the horizon, and taking a deep breath symbolizes the start of a new journey. The path to overcoming inadmissibility may have been challenging, but it has also been a journey of growth and self-discovery. With a renewed sense of purpose and determination, individuals can move forward with confidence and hope. Walking towards the Canadian flag with a smile of determination and embracing the future represents the culmination of the journey. It is a powerful symbol of resilience, hope, and the endless possibilities that await. The impact of inadmissibility may have been profound, but the journey to overcome it is a testament to the strength of the human spirit and the unwavering pursuit of one's dreams. Navigating the complex world of Canadian immigration law can be daunting, especially when dealing with criminal inadmissibility. The legal landscape is filled with intricate rules, regulations, and procedures that can be overwhelming for anyone unfamiliar with the system. Criminal inadmissibility can arise from various situations such as past convictions, charges, or even certain behaviors that are deemed unacceptable under Canadian law. Understanding the nuances of these laws is crucial for anyone seeking to enter or remain in Canada. Fortunately, individuals facing such challenges are not alone. There are numerous resources and professionals available to help navigate these complex issues. Support groups, community organizations, and legal aid services can provide initial guidance and support. However, for those dealing with criminal inadmissibility, the expertise of an immigration lawyer is often indispensable. These professionals are well-versed in the intricacies of immigration law and can offer tailored advice and strategies to address specific situations. Experienced immigration lawyers specialize in this area of law and can provide invaluable assistance. They have a deep understanding of the legal framework and are adept at interpreting and applying the law to individual cases. Their expertise extends beyond just knowing the law. They also understand the procedural aspects and can navigate the bureaucratic maze that often accompanies immigration cases. This specialized knowledge is crucial for anyone facing criminal inadmissibility, as the stakes are high and the consequences of missteps can be severe. The first crucial step for anyone seeking to overcome criminal inadmissibility is to consult with a qualified Canadian immigration lawyer. This initial consultation is an opportunity to discuss the specifics of the case, understand the potential challenges, and explore possible solutions. During this meeting, the lawyer will review the individual's history, including any past convictions or charges, and assess how these might impact their immigration status. This assessment is critical in determining the best course of action and setting realistic expectations for the outcome. These legal professionals possess the expertise to assess the specific circumstances of a case, determine the applicable legal provisions, and advise on the most appropriate course of action. They can identify potential legal remedies, such as applying for a temporary resident permit, TRP, or criminal rehabilitation, which can allow individuals to enter or remain in Canada despite their inadmissibility. Each case is unique, and the lawyer's role is to tailor their advice and strategy to the individual's specific situation, ensuring that all legal avenues are explored. Immigration lawyers play a critical role in guiding individuals through the often complicated legal processes, ensuring that all necessary documentation is in order and representing their clients' best interests before Canadian immigration authorities. This includes preparing and submitting applications, gathering supporting documents, and providing representation during hearings or interviews. The lawyer's involvement can significantly increase the chances of a successful outcome, as they can anticipate potential issues and address them proactively. Seeking legal counsel is not an admission of guilt or a guarantee of a favorable outcome. Rather, it is a prudent and strategic move to ensure that one's rights are protected, all legal options are explored, and the best possible case is presented to Canadian immigration officials. The lawyer's role is to advocate on behalf of their client, presenting their case in the most favorable light and arguing for their right to enter or remain in Canada. This advocacy is essential, as immigration authorities have significant discretion in their decisions, and a well-prepared case can make a substantial difference. Rather, it is a prudent and strategic move to ensure that one's rights are protected, all legal options are explored, and the best possible case is presented to Canadian immigration officials. The lawyer's role is to advocate on behalf of their client, presenting their case in the most favorable light and arguing for their right to enter or remain in Canada. This advocacy is essential, as immigration authorities have significant discretion in their decisions, and a well-prepared case can make a substantial difference. Additionally, the lawyer can provide emotional support and reassurance during what is often a stressful and uncertain time. Knowing that a knowledgeable and experienced professional is handling the case can provide peace of mind and allow individuals to focus on other aspects of their lives. Beyond individual legal representation, there are also community resources available to those facing criminal inadmissibility. Community organizations often offer workshops, information sessions, and support groups that can provide valuable information and assistance. These resources can help individuals understand their rights, learn about the legal process, and connect with others who are facing similar challenges. While these resources are not a substitute for professional legal advice, they can complement the work of an immigration lawyer and provide additional support. In addition to community resources, there are also government programs and initiatives designed to assist individuals with criminal inadmissibility. For example, the Canadian government offers the Temporary Resident Permit (TRP) program, which allows individuals who are otherwise inadmissible to enter or remain in Canada for a specified period. This program is designed to address situations where there are compelling reasons for allowing the individual to enter or stay in the country, despite their inadmissibility. Applying for a TRP can be a complex process, and the assistance of an immigration lawyer can be invaluable in preparing a strong application. Another option for overcoming criminal inadmissibility is criminal rehabilitation. This process allows individuals who have been convicted of a crime to apply for permanent relief from their inadmissibility. To be eligible for criminal rehabilitation, a certain amount of time must have passed since the completion of the individual's sentence, and they must demonstrate that they have been rehabilitated and are unlikely to reoffend. This process involves a thorough review of the individual's history and behavior since their conviction, and the assistance of an immigration lawyer can be crucial in presenting a compelling case for rehabilitation. In some cases, individuals may also be eligible for a record suspension, formerly known as a pardon, from the Parole Board of Canada. A record suspension can remove the disqualifying effect of a criminal record, making it easier for individuals to overcome criminal inadmissibility. The process for obtaining a record suspension involves a detailed application and a review of the individual's criminal history and behavior since their conviction. An immigration lawyer can assist with this process, ensuring that the application is complete and persuasive. It is important to note that each case of criminal inadmissibility is unique, and the best approach will depend on the specific circumstances of the individual. Factors such as the nature and severity of the offense, the time that has passed since the conviction, and the individual's behavior since the offense will all play a role in determining the most appropriate course of action. An immigration lawyer can provide personalized advice and develop a strategy that takes into account all of these factors, maximizing the chances of a successful outcome. In conclusion, overcoming criminal inadmissibility in Canada is a complex and challenging process, but it is not insurmountable. With the assistance of an experienced immigration lawyer, individuals can navigate the legal landscape, explore all available options, and present the strongest possible case to Canadian immigration authorities. By seeking legal counsel, individuals can ensure that their rights are protected, their case is thoroughly prepared, and they have the best chance of achieving a favorable outcome. Whether through applying for a temporary resident permit, criminal rehabilitation, or a record suspension, there are pathways available for those willing to take the necessary steps and seek the right support. Remember, the journey to overcoming criminal inadmissibility may be long and challenging, but with the right guidance and support, it is possible to achieve your goals and build a new life in Canada. Don't hesitate to reach out to an immigration lawyer and take the first step towards resolving your inadmissibility issues. With determination, perseverance, and the right legal assistance, you can overcome the obstacles and move forward with confidence. The path to overcoming criminal inadmissibility is not just about legal processes, it's also about personal growth and transformation. Many individuals who have faced these challenges have used the experience as an opportunity to reflect on their past, make positive changes, and build a better future. By working with an immigration lawyer and accessing available resources, you can turn a difficult situation into a chance for personal and professional growth. Embrace the journey, stay focused on your goals, and remember that with the right support, you can overcome any obstacle. In addition to legal assistance, consider seeking support from community organizations, counseling services, and support groups. These resources can provide emotional support, practical advice, and a sense of community during a challenging time. Surrounding yourself with supportive people and accessing available resources can make a significant difference in your journey to overcoming criminal inadmissibility. Remember, you are not alone, and there are many people and organizations ready to help you succeed. Finally, stay informed and proactive. Keep up to date with changes in immigration law and policy, and be prepared to adapt your strategy as needed. The legal landscape is constantly evolving, and staying informed can help you make the best decisions for your case. Work closely with your immigration lawyer, ask questions, and stay engaged in the process. By taking an active role in your case and staying informed, you can increase your chances of a successful outcome and move forward with confidence. Overcoming criminal inadmissibility is a challenging journey, but with the right support, resources, and determination, it is possible to achieve your goals and build a new life in Canada. Remember, you have the power to shape your future, and with the right guidance, you can overcome any obstacle. Reach out to an immigration lawyer, access available resources, and stay focused on your goals. With perseverance and the right support, you can overcome criminal inadmissibility and create a brighter future for yourself and your loved ones. Thank you for watching. If you found this information helpful, please like, share, and subscribe for more content on immigration law and overcoming legal challenges. Together, we can navigate the complexities of the legal system and achieve our goals. Stay positive, stay informed, and remember that with the right support, anything is possible. Options for overcoming inadmissibility. Thank you for watching. Like, share, and subscribe. As we delve deeper into the intricacies of Donald Trump's potential inadmissibility to Canada, we find ourselves navigating a complex web of legalities and regulations that govern cross-border movements. This issue is not just about one individual, but touches upon broader themes of international law, immigration policies, and the intricate balance between national security and individual rights. We will unravel the legal framework that governs such cases, starting with the foundational principles of Canadian immigration law. Understanding the Canadian legal perspective is key to comprehending the potential hurdles and opportunities that lie ahead for the former U.S. president. Canada's Immigration and Refugee Protection Act, IARPA, is the cornerstone of this framework, outlining the criteria for admissibility and inadmissibility. This act is designed to protect the health, safety, and security of Canadians, while ensuring that immigration processes are fair and transparent. Our exploration will take us through the intricacies of how Canadian authorities assess foreign convictions. This process involves a meticulous examination of the nature and circumstances of the offense, the legal standards of the country where the conviction occurred, and the equivalency of the offense under Canadian law. Canadian immigration officers are trained to scrutinize foreign convictions with a fine-tooth comb, ensuring that each case is evaluated on its own merits. The criteria for determining the severity of offenses are multifaceted. They include the type of crime committed, the length of the sentence imposed, and the time elapsed since the conviction. For instance, crimes involving violence, drug trafficking, or significant financial fraud are often viewed with greater severity. The Canadian legal system also considers whether the individual has shown remorse, taken responsibility for their actions, and made efforts to rehabilitate. The factors considered when evaluating an individual's rehabilitation and potential risk to Canadian society are equally comprehensive. These factors include the individual's behavior since the conviction, their personal and professional achievements, and their overall contribution to society. Canadian authorities also assess the likelihood of reoffending, which involves a detailed analysis of the individual's current lifestyle, support systems, and any ongoing legal or personal issues. We will shed light on the specific legal remedies available to individuals seeking to overcome criminal inadmissibility. One such remedy is the Temporary Resident Permit, TRP, which allows individuals who are otherwise inadmissible to enter Canada for a specific purpose and duration. The TRP process involves a thorough assessment of the individual's reasons for entering Canada, the potential benefits to Canadian society, and any risks associated with their entry. Another important remedy is the criminal rehabilitation application. This process is available to individuals who have completed their sentences and demonstrated a significant period of good behavior. The criminal rehabilitation application requires detailed documentation of the individual's criminal history, evidence of rehabilitation, and letters of support from community members, employers, or legal professionals. Successful applicants are deemed rehabilitated and no longer considered inadmissible to Canada. Each avenue comes with its own set of requirements, processes, and potential outcomes. The TRP is often seen as a temporary solution, providing short-term access to Canada, while criminal rehabilitation offers a more permanent resolution. However, both processes are rigorous and require a substantial amount of preparation, documentation, and legal expertise. The outcomes can vary widely, depending on the specifics of each case and the discretion of the immigration officers involved. By closely examining Trump's situation and the applicable Canadian immigration laws, we aim to provide a comprehensive understanding of the complexities surrounding criminal inadmissibility. Trump's case is particularly unique due to his high-profile status, the nature of the allegations against him, and the potential political implications of his inadmissibility. This case serves as a lens through which we can explore the broader issues of how criminal records are treated in the context of international travel and immigration. We will also explore the potential pathways to regaining entry into Canada, which may include legal appeals, diplomatic interventions, or changes in the individual's circumstances. Understanding these pathways is crucial for anyone facing similar challenges, as it provides a roadmap for navigating the complex and often daunting process of overcoming criminal inadmissibility. Through this detailed analysis, we hope to shed light on the legal, social, and political dimensions of this issue, offering insights that are both informative and thought-provoking. To grasp the potential barriers facing Donald Trump, we need to dissect the labyrinthine world of Canadian immigration law, particularly the concept of criminal inadmissibility. Canada, with its reputation for openness and acceptance, might seem like an easy target for anyone seeking a fresh start. However, the Great White North has a strict stance against allowing individuals with criminal pasts to waltz in. This principle, known as criminal inadmissibility, isn't about punishing past deeds. It's about safeguarding the peace and order of Canadian society, ensuring that those welcomed into the fold won't pose a threat. So, how does Canada determine who's admissible and who's not? The process is meticulous, involving a deep dive into the nitty-gritty of an individual's criminal history, scrutinizing every charge and conviction. Here's where things get tricky. Canada doesn't simply glance at a foreign rap sheet and make a snap judgment. It employs a process called equivalency analysis, carefully matching foreign offenses to their counterparts in the Canadian legal system. Think of it like translating a foreign language. A crime called one thing in another country might have a different name or legal definition in Canada. The goal is to understand how the crime would be classified and prosecuted under Canadian law. For instance, what constitutes fraud in the United States might not perfectly align with the legal definition of fraud in Canada. The nuances matter. A minor offense elsewhere could be deemed more serious north of the border. This meticulous comparison ensures fairness and consistency, preventing individuals from escaping the consequences of their actions simply by crossing borders. It's about holding everyone accountable to the same standard, regardless of where their transgressions occurred. Once Canadian authorities establish the Canadian equivalent of a foreign offense, they then categorize it as either serious or non-serious. This classification is crucial, as it significantly impacts an individual's admissibility prospects. The dividing line often hinges on the potential punishment for the crime. Offenses carrying a maximum prison sentence of less than 10 years generally fall under the non-serious umbrella. Think petty theft, minor drug possession, or low-level fraud. On the flip side, serious criminality encompasses offenses with a maximum sentence of 10 years or more. These are the heavy hitters, crimes like assault, drug trafficking, and major financial fraud. Why does this distinction matter? Because the severity of the crime directly influences the legal hurdles an individual must overcome. Serious criminality throws up significant roadblocks, making it considerably tougher to gain entry into Canada. Now, let's turn our attention back to Donald Trump. The 45th President of the United States found himself entangled in a web of legal woes, culminating in a conviction on 34 felony counts of falsification of business records. These charges stemmed from allegations that Trump, during his 2016 presidential campaign, orchestrated hush money payments to an adult film star to suppress potentially damaging information. While the case unfolded in a New York courtroom, its echoes reverberated across the border, raising questions about Trump's ability to set foot on Canadian soil. To understand why, we need to examine his charges through a Canadian legal lens. The crux of the matter lies in determining whether Trump's alleged financial misdeeds, specifically the falsification of business records, would be considered a serious or non-serious offense under Canadian law. In Canada, financial crimes, particularly those involving large sums of money or sophisticated schemes, are not taken lightly. The Canadian Criminal Code outlines a range of offenses related to fraud, each carrying its own set of penalties. Falsification of business records, the very charge leveled against Trump, finds its Canadian equivalent in offenses such as fraud, uttering forged documents, and fraudulent concealment. These crimes target dishonesty and deception in financial dealings. The severity of these offenses in Canada often hinges on the amount of money involved, the sophistication of the scheme, and the intent behind the actions. The greater the financial harm and the more calculated the deception, the harsher the potential consequences. Given the high-profile nature of Trump's case and the substantial sums of money allegedly involved, Canadian authorities would likely scrutinize his actions through the lens of serious financial criminality. Determining whether Trump's offenses would be classified as serious or non-serious in Canada requires a careful analysis of the Canadian Criminal Code and relevant case law. Factors such as the potential for significant financial harm, the element of public trust breached, and the sophistication of the alleged scheme would all weigh heavily in the assessment. Given the potential for significant penalties associated with similar financial crimes in Canada, it is highly probable that Trump's offenses would fall under the umbrella of serious criminality. This classification would have significant implications for Trump's ability to enter Canada, as it would trigger a higher threshold for overcoming inadmissibility. To fully grasp the potential consequences for Trump, it's important to understand a bit of Canadian legal jargon. In Canada, criminal offenses are broadly categorized as either indictable or summary offenses. Think of indictable offenses as the heavyweights of the criminal justice system. These are serious crimes that can carry hefty penalties, including lengthy prison sentences. Murder, kidnapping, and major drug trafficking all fall under this category. On the other hand, summary offenses are less serious in nature. They typically involve lesser penalties, such as fines or shorter jail terms. Think minor theft, public disturbance, or traffic violations. The distinction between indictable and summary offenses is crucial in determining criminal inadmissibility. Being convicted of an indictable offense, especially one with a maximum sentence of 10 years or more, significantly increases the likelihood of being deemed inadmissible to Canada. Canadian immigration authorities pay close attention to the maximum sentences associated with criminal offenses, both in Canada and in the country where the conviction occurred. The rationale is simple. The longer the potential prison term, the more serious the crime is considered to be. This principle applies even if the individual received a lesser sentence than the maximum allowed by law. For instance, if someone is convicted of a crime in another country that carries a maximum sentence of 15 years, but they only serve 5 years, Canadian authorities would still consider the offense serious due to the 15-year maximum penalty. This focus on maximum sentences underscores Canada's commitment to protecting public safety and ensuring that individuals with a history of serious criminality are not granted entry. Given the nature of the charges against him and the potential for his offenses to be classified as serious criminality in Canada, Trump could find himself facing an uphill battle should he wish to cross the border. The Canadian government has a clear mandate to protect its citizens and maintain the integrity of its immigration system. Allowing individuals with serious criminal backgrounds to enter the country could be perceived as undermining that mandate. This is not to say that Trump would be permanently banned from Canada. However, he would likely need to explore legal avenues to overcome his inadmissibility, a process that could be both lengthy and costly. His case highlights the complexities of criminal inadmissibility and the potential consequences for individuals, regardless of their status or prior accomplishments. Overcoming criminal inadmissibility to Canada is not just a matter of legal wrangling. It also involves navigating a complex system of fees and applications. And guess what? The price tag for seeking entry varies depending on the severity of the crime. Those with non-serious offenses face a lower processing fee, currently set at $229.77 CAD. However, for those grappling with serious criminality, the cost of seeking redemption skyrockets. The processing fee for overcoming serious inadmissibility currently stands at $1,148.87 CAD, a five-fold increase. This financial disparity underscores the seriousness with which Canada treats serious criminality. It's a stark reminder that seeking entry after committing a serious offense comes at a higher cost, both literally and figuratively. Facing the prospect of being deemed criminally inadmissible to Canada can be a daunting and overwhelming experience. The legal complexities, the potential consequences, and the emotional toll can feel insurmountable. That's precisely why seeking expert guidance from a Canadian immigration lawyer is not just advisable, it's essential. These legal eagles specialize in the intricate world of Canadian immigration law and know the ins and outs of criminal inadmissibility like the back of their hands. A seasoned immigration lawyer can provide invaluable assistance in navigating this complex terrain. They can assess the specific circumstances of a case, determine the applicable legal provisions, and advise on the most strategic course of action. Think of them as your legal Sherpas, guiding you through the treacherous mountain passes of Canadian immigration law, ensuring you don't stumble and fall along the way. So let's say Donald Trump, with his legal baggage in tow, sets his sights on visiting the Great White North. What options does he have? Can he simply hop on a plane and breeze through customs? Not so fast. Given his potential inadmissibility, Trump would need to explore specific legal remedies to gain entry. Two potential avenues exist: applying for a temporary resident permit, TRP, or seeking criminal rehabilitation. Each option comes with its own set of requirements, processes, and chances of success. The choice of which path to pursue would depend on a variety of factors, including the urgency of travel, the strength of the case, and long-term goals. It's like choosing between a scenic detour or a major highway overhaul. One offers a temporary fix while the other aims for a permanent solution. For individuals seeking a temporary reprieve from inadmissibility, the Temporary Resident Permit, TRP, offers a potential lifeline. Think of it as a temporary hall pass, granting entry to those who might otherwise be turned away at the border. TRPs are typically granted for specific purposes, such as visiting family, attending business meetings, or receiving medical treatment. They're not a free pass to set up shop in Canada. They're meant for short-term stays with clearly defined reasons. The million-dollar question, of course, is whether Trump would qualify for a TRP. The answer, as with most things in law, is it depends. Canadian authorities would scrutinize his application, weighing the potential risks he poses against the benefits of his visit. Factors like the purpose of travel, the duration of the stay, ties to his home country, and the potential threat to public safety would all be carefully considered. It's a judgment call, balancing compassion with caution.